Greetings. My name is Kyle Soley, and with me is my partner, Steve Blazek. We're both partners at the law firm Reed Smith. Those of you who don't know, Reed Smith is an international law firm with offices all over the world. But important and relevant to those of you tuning in today, Reed Smith has the largest state tax practice in the country, with over 30 lawyers practicing state tax around the country in 6 offices, including Philadelphia. In Philadelphia, Reed Smith has the largest state tax practice of any law firm in the country. And that's what we're going to be talking about today, the City of Philadelphia. We're going to be talking in particular about the business income and receipts tax that the City of Philadelphia imposes. It's a whopping tax, over 6%. And if you couple that with the 10% tax imposed at the state level, you'll see that the city and state impose a tax of 16%, which makes it the largest tax burden of any jurisdiction in the country. What we're going to be talking about today is that the City of Philadelphia doubled the tax for many out-of-city companies by changing the method of apportionment. And we're going to argue, Steve and I are going to argue, the city did not have the authority to do that. So today, our argument is going to take the place of a walk through the city's authority and what you as a taxpayer can do in response to that. So our agenda, first of all, starts with the history of the BIRT. Steve's going to walk through where did the BIRT come from, the business income and receipts tax, where did that tax come from? We're going to then talk about the legal authority for apportionment under the BIRT. There is apportionment in the BIRT. Where did that authority come from? And then we're going to talk about the move to the single sales factor. That's the whole problem here. Now we have the single sales factor. We're going to talk about the move there. Right. And then as a backdrop to our argument that the city lacked the authority, we're going to talk about the state constitution. What's the state constitutional authority for changing apportionment? Right. And then we'll talk a little bit about the city's rules, the home rule charter, and how the city's rules work around that. So our conclusion, again, spoiler alert, our conclusion is the city did not have the authority to move to single sales factor apportionment. So we're going to conclude with Steve sort of giving well, what do we do now? What's the next steps? And so with that, I'm going to turn it over to Steve to talk a little bit about the history of the BIRT.
Oh, thank you, Kyle. Yeah, we wanted to start with a brief history of the BIRT and how it came to be. Prior to the enactment of the business income receipts tax in Philadelphia, the city only taxed gross receipts of businesses. There was a tax called the mercantile license tax at that time, and again, that was only a tax on receipts. In 1984, dissatisfied with its revenue under that tax, the city of Philadelphia went to the General Assembly in Harrisburg, where they get their authority to tax, where the city receives its authority to tax. They went to the General Assembly in Harrisburg and requested the authority to tax income and receipts. And the General Assembly in Harrisburg complied. And in 1984, the General Assembly passed what is called the First Class City Business Tax Reform.
It's a mouthful, isn't it? You can't use like a one-word thing. Yeah, you got 6 words, right?
First Class City Business Tax Reform Act of 1984. And what that enabling act, that state legislation did, was permit the city to tax receipts or income or both. So that's 1984. Wasting no time, in 1985, the city enacted the business privilege tax. And as Kyle mentioned, there's an income component and a gross receipts component, and that was the business privilege tax of 1985. In 2011, dissatisfied with the name of that tax, the City Council of Philadelphia changed the name of the tax from the business privilege tax to the business income and receipts tax, or the BIRT.
Now, so the name change there is interesting. So the City Council was dissatisfied with the name business privilege tax. They thought, people would think maybe it's not so much of a privilege to do business in the city of Philadelphia. So they changed the name. They keep everything else the same about the tax, but they change it from business privilege tax to the BIRT, business income and receipts tax.
And I do recall the political climate at that time and the articles in the paper, and that really was, people were just angered by the fact that they were paying a tax on the privilege of doing business in Philadelphia. So anyway, name change in 2011. Now, going back to the Business Tax Reform Act of 1984, that state enabling statute, as I said earlier, that gave the city the authority to tax income and receipts of the taxpayer, and it also permitted the city council to enact tax rates. What that state enabling legislation didn't do, what it did not do, was grant the city council the authority to issue apportionment rules or regulations. Rather, what it did was it gave that authority to the revenue commissioner in Philadelphia. Now, I know you may be thinking, that's typically not how it's done. Typically, the legislature or elected body is given the authority to issue apportionment rules, but not under the Business Tax Reform Act of 1984. Again, that gave the authority for apportionment rules and regulations to the revenue commissioner, an unelected official. So, what does the state enabling legislation say? Well, it says that the revenue commissioner shall promulgate rules and regulations regarding the apportionment of income from businesses to Philadelphia. Now, it's not blanket authority. There is qualification on that. The State Enabling Act states that the commissioner must give due regard to 4 factors. The first factor being the nature of the business. The second factor, the payroll of the business in Philadelphia, the property of the business in Philadelphia, and the sales of the business in Philadelphia. So again, Revenue Commissioner has the authority to issue apportionment rules, but again, it must give due regard to those 4 factors.
And so, Steve, this language is due regard language that you see in the statute. That could mean, it sort of has this, you get this impression of discretion that comes out of that language, that the revenue commissioner can sort of pick and choose and decide. But due regard, as we're going to talk a little bit later, can't mean disregard. Right. In other words, the revenue commissioner needs to glean some meaning out of that statute, some guidance out of that statute. And if she ends up not giving any regard to those elements that the legislature gave to her, then we may have a statutory problem with the delegation of authority.
Yeah. I think it's important to point out under that State Enabling Act that for regulated industries, that is industries such as banks, thrifts, insurance companies, for regulated industries, they are to apportion, they're required to apportion their income to Philadelphia based on a single sales factor. Not this property, payroll, and sales, but based on a single sales factor. And we think this is strong evidence that suggests that the General Assembly, if it wanted to, it could have taxed apportioned income from non-regulated industries based on a single sales factor, but instead it had different language, it had that due regard, and those 4 different factors. So we think that's strong evidence that the General Assembly knew what it was doing. So as I mentioned earlier, 1985, City Council passes the business privilege tax, and the Revenue Commissioner at that time must ostensibly gave due regard to the property, payroll, and sales that mentioned under the State Enabling Act, because she enacted a regulation that apportioned income to Philadelphia based on property, payroll, and sales. So that's 1985. 1990s come around, and the Revenue Commissioner issues a separate regulation, but adds an additional factor to the apportionment formula and makes it a 4-factor apportionment formula, really just double weighting the sales factor. So it's property, payroll, sales, and sales. So that's 1990s.
And then still, though, I mean, makes a change, still gives regard of some sort to property and payroll. So you still have the elements of property and payroll, which the General Assembly had mandated in the Enabling Act in the apportionment regulation.
Right.
So you didn't see the same sort of soul searching that you see now, that we have no property or payroll. Now that we've moved to single sales tax, you don't see the same sort of outrage by taxpayers, right, increase in their tax liability as a result of the change to a double-weighted sales factor.
Yes. Yes. So that was 1990s, 4-factor formula. So how did we get here? How do we get to the single sales factor? How do we arrive at this point? As I mentioned earlier, under the State Enabling Act, the City Council doesn't have the authority to enact apportionment rules. And they don't believe that they have the authority either. You take a look at what they did in 2011 to try to arrive at a single sales factor. They tried to do it by enacting a credit. So 2011, City Council passes an ordinance that permits taxpayers to use a single sales factor credit beginning with the 2013 tax year. Now, how this worked was you would calculate your business income receipts tax based on that four-factor property, payroll, sales, and sales. You calculate your tax based on that formula, and then you separately calculate your tax based on a single sales factor. And the difference between those two amounts is your single sales factor credit. So in essence, it was as if you were calculating your tax under a single sales factor, but it wasn't an apportionment methodology. It was a credit. And this credit was only to help taxpayers. It wasn't mandatory. So if you're at a city taxpayer, you didn't have to take this. You didn't have to calculate your tax based on a single sales factor. So it was only there to benefit taxpayers. But what that 2000 legislation or ordinance contained was a provision that allowed the Revenue Commissioner to revenue score that single sales factor credit and disallow it if she chose. And she did. In 2013, she disallowed the credit, and in 2014, she disallowed the credit as well. So no credit was allowed, and we're still calculating tax for 2013 and 14 based on that four-factor formula.
So we had with the single sales factor credit. I mean, even though the commissioner City Council was aware that there is pressure from in-city companies. The burden on the taxpayers in the city is high. They don't actually change to a single sales factor. What they do, Steve, is they enact this credit mechanism. City Council enacts a credit mechanism. They know they can't enact apportionment.
Right.
They enact this credit mechanism to give relief to in-city taxpayers, but it's not really apportionment, because it's not really going to reach out to out-of-city taxpayers and make them pay more. It's just a one-way street. It's just it would be a revenue, if you would, relief or giveaway to the in-city taxpayers, because City Council realizes that's all it can do. It doesn't have the authority to do the apportionment. Is that a fair way of?
I think it's a very fair way to look at it. And then City Council, I guess, maybe had a crystal ball because that ordinance also had a provision in it as well. That 2011 ordinance had a provision in it as well that if the Revenue Commissioner did enact apportionment rules requiring income to be apportioned based on the single sales factor, that single sales factor credit would be revoked. That would be revoked. So that's 2011. A 2011 ordinance. Now let's go back to the future to 2015, in December of 2015. And what's going on right then is Mayor Nutter, Michael Nutter, is in his last month of office. There's a newly elected mayor, James Kenney, who's coming in office in January 2016. And the Revenue Commissioner, Clarence Holson, is in her last month of office as Revenue Commissioner.
Lame duck.
Lame duck. Total lame duck all the way around. So what does she do? December 18th, 2015, again, last month of office, she promulgates a regulation, passes a regulation requiring businesses to apportion their income based on a single sales factor. So that apportionment formula that was around since 1985, apportioning income through property, payroll, and sales, is done away by administrative fiat during the last month of her tenure. So you may have seen, you've heard Kyle and I mention that maybe this isn't the best way to do it. Maybe apportionment rules should be really given to an elected body, just like it's done in Pennsylvania, or it's done in the localities around Pennsylvania. So maybe it's not a good idea to give the apportionment authority to an unelected official, and Kyle's going to discuss that right now.
Okay, thanks, Steve. Yeah, so Steve and I, our basic idea here is that it's not okay at all. and we're going to look at a couple of reasons for that. First of all, we're going to look at the state constitution. The state constitution vests all legislative power in the General Assembly, and that's important for questions like this, because here we're dealing with apportionment. In a way, we're dealing with companies that are doing business in the city. How do you apportion their income in the city? How do you apportion it to the surrounding counties? It's the very kind of question that you would expect a state legislature with representatives from around the state to be deciding.
Yeah.
So you've got that. And then you've got the Pennsylvania Supreme Court. The Pennsylvania Supreme Court has clearly said that legislatures are the ones to make policy choices. So the question is whether apportionment, whether deciding to use a single sales factor or not is a policy choice, whether deciding to use property and payroll is a policy choice. Are those things policy choices? Well, let's take a look at what at the state level has happened for the last 80 years. At the state level, every time there's been an apportionment method for state taxes, that apportionment method has been established by the legislature, has been established by the General Assembly. We've got the corporate net income tax, we've got the franchise tax, we've got the bank shares tax, we've got the mutual thrift tax. Every tax at every level for 80 years that's been imposed by the state that needs apportionment, at least the basic apportionment decisions have been done by the General Assembly, the elected legislature. Occasionally, there may be a detail that needs to be worked out, and they'll let the Secretary of Revenue take care of the detail by regulation. But the basic notions of what goes in the factor, the basic policy decisions about whether we're going to use market or whether we're going to use the taxpayer activities, those are done by the legislature. In fact, as recently as a few years ago when the legislature in Pennsylvania at the state level went to a single sales factor, the very thing that the revenue commissioner in Philadelphia wanted to do by administrative fiat, the General Assembly needed to step in and make that choice. Right. So we think at least if you follow the guide of what the General Assembly has thought it needs to do, it's always thought that it needed to use legislation. So let's look at the city's authority. The city of Philadelphia is a home rule city. It has a home rule charter. So you may say to yourself, well, maybe the city of Philadelphia vests the revenue commissioner with some special authority that's different than what's going on in the state constitution. The answer to that is no, that's not happening at all. If you look at the home rule charter, it's explicit. In fact, it's even more explicit because it says that the legislative power shall be exclusively vested in city council. Yeah. So if we were going to make a switch from apportionment methods, and we were to say, well, maybe things are different in the city, if anything, it's more strict. There's an exclusive investment of those sort of decisions to be made by city council. Yeah. And then you look at other authorities or other sources for whether or not apportionment is the kind of thing that ought to be done through a legislature. Is it the kind of policy choice you'd expect to be legislative? And you'll see that for example, Professor Hellerstein in his treatise, he talks about apportionment. And although, again, there are certain details of apportionment you can do by way of regulation, the basic concepts of apportionment, the basic fundamental policy decisions, Professor Hellerstein thinks should be made by a legislature. So what do we do with that? Well, one thing to do is to say, look, the legislature here in the Business Tax Reform Act did not give us a policy choice, did not give us any sort of explicit policy choice when it comes to apportionment. It has this due regard language. Well, due regard doesn't explicitly say shall include. So maybe we'd say that there's no apportionment guidance at all. But I think if a court were to look at this, the court would say we are going to sort of read into the statute the guidance we need. When we read that due regard language that we looked at earlier, we're going to give it perhaps the color of shall include. Steve pointed out that the General Assembly had made special apportionment rules for the financial industry, allowed them to use a single sales factor apportionment. Well, let's look at that perhaps as a clue that the General Assembly was giving the Revenue Commissioner, that other companies, to give due regard to their property and due regard to their wages, you need to do something differently. Otherwise, if there isn't that, if we don't read into the legislation, into the statute, a structure for apportionment, then we think, under the authorities we've looked at, there's an unlawful delegation to the Revenue Commissioner. So what does that mean for us? Well, that means if you look at the due regard language and you say, I've got to glean a real structure, a real rule that the Revenue Commissioner has to follow, what that means is that we need to have a property factor and we need to have a payroll factor, that the Revenue Commissioner can't just switch after 30 plus years of having a apportionment with those elements, can't just switch without other legislation to a single sales factor. So Steve, where does that bring us? Okay, so if that's what we think, is that the Revenue Commissioner exceeded her authority by simply using a single sales factor, where does that leave us?
I think it leaves us in an interesting position. I think it leaves us with the taxpayer really having a choice whether they want to use single sales factor or some other apportionment method with property and payroll included in that apportionment formula. So for taxpayers where a single sales factor is beneficial, we would say those taxpayers can continue to use a single sales factor to apportion their income where it's beneficial. Where for those taxpayers where their tax increased, maybe even doubled, we think they have the authority to use an apportionment formula that includes property and payroll, as well as sales. So I say they have a choice, but given the penalty and interest in Philadelphia, and while it's not as bad as it used to be confiscatory, but while it's not as bad as it used to be, there still are significant penalties and interest for underpayment of tax. So while we say they can have a choice between filing methods, we suggest that you continue to file your business income receipts tax returns based on apportionment method of single sales factor. However, we do strongly suggest that for those taxpayers where their tax increased, again, maybe even doubled, that those taxpayers file refund claims with the City of Philadelphia Department of Revenue requesting a refund of tax and asserting their right to apportion their tax based on a property apportionment formula, or an apportionment formula that includes property, payroll, and sales as well. So that concludes our presentation. I want to thank you very much for joining us today. I know on this side of the wires it was very fun, and if you have any questions for us, please feel free to reach out to Kyle or me, and we'll be happy to discuss with you. Thank you and have a good day.